Good morning, all. So we are privileged to have you on our first webinar for the compliance center. Unfortunately, the speaker could not make it live today. He has sent his, kind of regret messages also. We'll be streaming his recording, which we made earlier this week, and we will get your questions answered over your email also. Thank you so much.
Privileged to have Mr. Anjal Raj, who is the regional counsel at Ferrero India, heading the legal department for the company's operations in South Asia. Good morning, all. Compliance 1010 Awards and Symposium is an industry event to recognize outstanding work in the areas of governance, risk, and compliance. It is also a platform for leaders to share their viewpoints on contextual and pertinent topics. This symposium garners the attention of over 60,000 industrial professionals. Compliance Center is a platform that recognizes exemplary performance in the compliance space. Mr. Deepak Parekh aptly labeled the Compliance Center as the Oscars of compliance. Over the years, the compliance crusaders like Mr. Adi Godrej, Anuaga, Mr. Narayan Murthy, Mr. Damodaran, Mr. Deepak Parekh, Mr. Raghunandan Mashelkar, Mr. Harish Sarve, and Mr. Venu Srinivasan have shared their views to an audience of over 60,000 compliance and risk professionals. And the major part of the Compliance 1010 is the Compliance Week, which is the Compliance and Ethics Week, which has various webinars and workshops. As a part of this Compliance Week, we arrange pioneers in the business to guide and enlighten our audiences. Today, we are honored and privileged to have Mr. Anjal Raj, who is the Regional Counsel at Ferrero India, heading the legal department for the company's operations in South Asia. Anjal comes with an experience of 17 plus years, which includes his initial years as a practicing lawyer in the Jharkhand High Court and the remaining term as an in-house lawyer in some of the world's renowned FMCG companies. He is passionate about compliance and has worked on several projects around this topic, helping organizations to prevent, find, and fix problems. He is keen on developing and working best practices with aid of organization in being risk averse in a complex regulatory environment. We also have Mr. Indranil Shinde, Company Secretary and Legal Counsel at Ferrero India. Having more than 13 years of experience in various fields such as corporate governance, litigations, contract management, data privacy, competition law, and general insurance. Indranil is also an avid electronic keyboard and a singing artist, and we are privileged to have both Anjal and Indranil as a part of this inaugural session of webinars. We thank you for making the time and spending the efforts.
Thank you, Jaideep, for this lovely introduction. As you mentioned rightly, compliance as a topic is very dear to the hearts of all the lawyers, all the organizations who are keen to follow the path of compliance. And what better way to talk about compliance than a compliance 10 on 10 symposium that Legasis is going through. I'm thankful to my team member, Indranil, who has taken the pains to pull up all the slides and important best practices that we follow in Ferrero India. Together with him, we will talk about few topics which may be of interest to you. The first topic that we are going to talk about today is on the FSSAI. It's one of the important regulators in our lives. We, being a food industry, are governed by the Food Safety and Standards Authority of India. We'll give you a brief overview about what FSSAI is and what are the rules and regulations that they govern. Some of the best practices that we have developed in terms of dealing with inspections and audits, which are a common factor whenever you are running a business in India or abroad. Inspections and audits are key to any organization and which keeps them on the toes and ensures that they are compliant in all ways. And the rules and regulations that are applicable to them are followed to the T. Indranil will take you through some plastic regulations, which is one of the very important topics currently. As we all know that the environment is going through a lot. The regulator and the government are trying to legislate these regulations to govern plastic waste, which will not only help curb the plastic waste menace that we are seeing in the environment, but also would help the industries to think and innovate to come up with better plastic alternatives, better alternatives to plastic rather. Mind you, all these regulations do bring in a lot of compliances on the organizations. And today is a very small effort of Indranil and mine to take you through the finer aspects of these two regulations and some of the best practices that we have come up with. Moving on, the first topic that we have is on FSSAI. But before I go there, what you see on the screen is a very common picture. A lot of us use this picture. What it means to us is that the iceberg are legal risks. The legal risks, we take them as icebergs, and what you see on the top of the water are legal cases, the resolutions that happen. But what stands under the water are the avoided risks, the prevention. So success, what you see is very easy to watch, but what goes, a lot of effort which goes is on the prevention. So that's what the iceberg talks about, that there's a lot of meat underwater which is not visible. Moving forward on the FSSAI overview, what I would want to talk about was that food law in India has come a long way. Earlier, there were a lot of legislations which governed food products within the Indian territory. Prevention of Food Adulteration Act being one of them, which was framed in 1954. There were 8 different laws governing the food sector, various different orders which were framed. A lot of authorities were involved in framing legislations. There was a lot of overlap between these legislations, and the regulators were not clear how to govern. There were a lot of criminal prosecutions which were being initiated against organizations and against individuals, even for minor offenses. The government therefore realized that it's time to bring in a legislation where there is uniformity. So as a result, the Food Safety Standards Authority of India came into picture in 2006. The act was framed in 2006. However, it again took 5 years to frame all the rules and regulations. What are the key functions of FSSAI? As you would all know, that FSSAI are the food regulators. They facilitate food safety. Whatever you see in the market are governed by the rules and regulations framed by the FSSAI. Well, have they covered every aspect of it? Maybe not. It's an ongoing work. It's an ongoing progress, which is being governed by this regulator. The work is never ending. They're regulating the manufacturing aspects, they're regulating the storage aspects, the distribution of food, the sale of food, as well as the import of food. And with each passing day, they're also increasing their ambit on exports as well. These are the authorities which lay down the science-based standards of food. So each food, what you're consuming, whether it's safe, unsafe, so there are all science-based standards which are governed by the FSSAI for the food that you consume. Let me give you a brief about the structure and key regulations, how the FSSAI works. The FSSAI is governed under the Ministry of Health and Family Welfare, and it's the administrative ministry of the FSSAI. There is a chairperson and 22 members who govern the FSSAI. They work towards securing the food standards. They have scientific panels which work on the food safety aspects. They work on the compliance and inspections. They have an advisory committee. They have a steering committee, and they have a district level advisory committee. And each state within India have their own FSSAI administrative offices which govern licensing, compliance, enforcement, and so on and so forth. There are various regulations which FSSAI has come up with. Some of the key ones you can see on the screen are the primary being the licensing and registration of food businesses. Well, one cannot continue with any food business if you are not licensed or registered. The other one is the food product standards and food additives. What goes inside the food? What is a food made of? What should a food be made of? This is something which is governed by the food product standards and food additives regulations. It's a very important one, a very technical one for us. What the consumers see is the next one on the shelves. Well, that is governed. What you and I see in the market on the shelves is governed by the labeling and display regulations. If you pick up a product on the shelf, you look back and front, the words that you see on the labels are the ones governed under the labeling and display regulations. They also govern the food imports. So whatever is coming from the out of India markets should comply to the Indian food regulations. So we have a specific regulation to govern import of food materials. And one of the most harped upon regulations is the advertising and claims regulations, because the food, what you see, are advertised, and claims, a lot of claims are made to advertise those food products. Well, you cannot claim the moon. So there are regulations to check you there, and that is governed by the Advertising and Claims Regulations 2018. There are other regulations as well, but we thought that these are the 4 or 5 regulations which are of key importance for today. We'll talk about the registration and licensing regulations first. A lot of work goes behind obtaining a license or a registration under the Food Act. All FBOs, now the FBOs means food business operators, the kirana shops, the stalls, the manufacturers, they're all called food business operators. They have to mandatorily obtain either a license or a registration from the food authority. You cannot operate in food products if you're not either licensed or registered. What are the kind of businesses for which the licenses are required? As you can see, it's manufacturing, it's exporting, it's storage, it's relabeling, it's repacking, it's importing, it's transporting, it's distributing. There can be many activities. If you're dealing with food, you need to be licensed. And with the license comes conditions. In addition to the regulations that one needs to follow, there are licensing conditions which one has to follow. They go over and above the regulations. So there are a lot of licenses which are annexed to the conditions, they are next to the licenses which one gets. There is a portal. With the age of digitalization, FSSAI is moving away from manual, handwritten giving of licenses to a digitized way of giving licenses. This is a big step that FSSAI has taken, and FOSCOS is a resultant of those efforts. So FOSCOS is the recent licensing portal which FSSAI has come up with, which gives you or grants you the licenses and registrations, gives you modifications, and so on and so forth. So each FBO or a food business operator is required to give all their details on the FOSCOS portal in order to generate licenses. So depending upon the kind of business turnover you have, the rules and regulations govern whether you will be needing to obtain a registration, which is a much easier process, or licensing, which is slightly stringent because there are a lot of compliances involved. Then in addition to the state licenses, there are central licenses also involved. If you are operating in more than 2 or more states, you need to obtain a central license. And if you're operating in one state or you have a turnover of a particular category, then you can obtain a state license only. What are the challenges in licensing? Licensing doesn't come easy. Well, it seems to be easy, but there are a lot of hard work goes before one obtains a license, technical as well as legal. So one needs to be very sure about what products they are manufacturing. One needs to be very sure that the products that they are going to introduce in the market, or the activity, be it manufacturing, storage, transportation, whatever activity they are going to undertake, they follow the rules and regulations governed by the FSSAI. So a lot of hard work goes before making the license application, so that whenever there are any queries which are raised by the FSSAI officers, the licensing officers, one can resolve it. Because each and every license application is scrutinized by the designated officer, which is the licensing officer, very minutely. Even if you modify your license, so if you've obtained a license after much of your hard work, even if you modify your license to add in a product or to change any location that you might have changed, your modification application will also be looked into as a fresh application. So the licensing officer has the authority to go and question you on all the previously licensed aspects as well. So one needs to be very certain, very sure in terms of internal documentation of what are the arguments that we had taken while obtaining the initial licenses. So that's one of the aspects that we take care very particularly, that we prepare a dossier, we have a dossier very well prepared where all the stakeholders agree to a particular point. When we discuss that point with the regulator, we keep it documented so that later on, if the licensing officer gets changed, whoever the new person comes in has a history behind the discussions of licensing. While FSSAI has a time frame of 60 days to revert, 60 days may seem to be a lot of time when your business asks you to, run and seek a license at an early stage. So 60 days is what is governed by the legislation. However, the regulators or the legislator or the licensing officer are efficient enough. The licensing officer and the team are efficient enough to grant a license even before 60 days, cross. So there are very few cases that we've seen that a 60-day period is taken. They're efficient enough, but the only condition is that you need to be ready with all the prerequisites, the documentation that is required for them to easily grant you a license. There are a few interpretational challenges which may come over the methodology of seeking your license. The interpretational challenges would be legal related. It may be related to the food technology, where the regulator is of a particular point of view, the industry will be of a particular point of view. It's best that you sit across the table with the regulator, their technical team versus your technical team, discuss those points, argue those points before the technical officer so that you can satisfy all their queries. And also be ready if you think that the regulator is maybe kind of right in terms of their interpretation, then be ready to take a step back, because each and every argument will increase your number of days at which your license will be granted. So it's a call that needs to be taken on each and every occasion. So these are some of the challenges which one faces while obtaining the license. Or a registration, again, is much easier because it's for a FBO who has a very low turnover. For licensing, for industries like us, one needs to be very careful about the documentation that one has. Moving on to the food additives regulations. Now, this is again an important regulation, as I mentioned. It governs what you are eating, what can be added to those products, whether it needs to be standard, whether it's a proprietary. Now, under the food additives regulations, all the foods that you see in the market currently in India are governed under these regulations. The standards and the perimeters that each of such product needs to follow is given in that book in these regulations. So each product either falls under the standard category, where all the additives, all the vitamins, all the minerals, all the nutrients which go into the product are as per the guidelines provided by the law. Or if a food product doesn't have the ingredients and additives as prescribed, it has an ingredient or an additive which is standardized by these regulations. What I mean to say is, for example, chocolates. There are standards of chocolates fixed in the food additives regulations. Now, chocolates may have ingredient A, B, C, which is prescribed by the food regulations. But if I add an ingredient D, which is not part of the standard chocolate category, I cannot call my product, I may not call my product a chocolate, but I may call my product something which is closer to some other category. So that's where the concept of proprietary comes in. And here is where another challenge comes in. Standard product licensing is very easy, but when you're applying for a proprietary product, which is slightly deviating from the standard product, you have to demonstrate, or the industry has to demonstrate, that the product that you're introducing in the market is not unsafe. While you're using all the standard ingredients in those products, it's the responsibility of the FBO to prove that those products are not unsafe. And here is where a lot of questioning comes from the licensing officer, because they want to be very sure of the proprietary products which are getting into the market. The proprietary products cannot deviate from any quality parameters. They can use only ingredients which are standardized under FSSAI or permissible under these regulations. They cannot use any ingredient which is not standardized. So a lot of checks and balances are applied for a proprietary food. The additives as well has to be used as per the prescriptions given in the FSSAI additives regulations. So this is a slight difference between what a standard product is and what a proprietary product is. Tomorrow, once you're there in the market, pick any food product and just check what are the kind of declarations which are mentioned on its label. If it's a proprietary product, they would clearly call it out on the back of pack of the label or front of pack now that it's a proprietary food. The next regulation that is very crucial for us is the labeling and display regulation. What you see on the shelves, what you see on the packaging of any food product, the back of pack, front of pack, are these mandatory declarations which are governed under the labeling and display. These have been made effective with certain modifications and amendments starting 1st July 2022. There are a lot of increase in the number of declarations since July 2022 which have been brought in. The wedge logo and the commercial name of the product needs to come on the front of pack. So any pack which is front facing in the market, you can see now that the wedge logo and the name of the product is mentioned on the front of the pack. Earlier, it used to be written in the back of pack. This initiative has been brought in to give more clarity and more visibility to the consumers who go to the shelves and take the products. So whether my product is a veg or a non-veg can be easily determined now, because these declarations are given on the front of pack. Font sizes are again a very contentious issue, but a very good initiative by the regulator. Font sizes are the ones where the regulator is intending that the consumers should easily read all the declarations which are mentioned on the label. So in earlier days, the branding of the products was larger, but the mandatory declarations, the font sizes were small. In order to avoid that, the regulators have now brought in amendments where the font sizes have been prescribed, and the font sizes keep increasing every year. This is a contention between the industry and the regulator because there are space constraints also. For smaller packages, there is not much space left. And in addition to FSSAI, there are other regulators who want certain declarations put on the label. But the industry, nevertheless, is currently complying with all the sizing requirements given in the FSSAI. The nutrition table that you see on the back of pack has a lot of material that one can read. The expiry and the best before is an optional item which has been given. So expiry has to be given, but the best before date, which was earlier mandatory, has now been made optional. So now in the food products also, you will find expiry dates being mentioned. The serve sizes, how much serve size, what's the serve size of pack, has been added by way of the new declarations. And certain declarations with regard to the non-retail containers, the containers in which these primary food products are stored. So how those non-retail containers have to be labeled are also now governed under the labeling and display regulations. So a lot of compliances again come in. A lot of dialogue happens with the regulator where the industry needs to be cautious and conscious about the mandatory law that they need to follow, because any non-compliance would again lead to litigation or resulting into fines and penalties. The food import regulations, as I mentioned, are meant for products which are again being imported into the country. There are a lot of licensing requirements again for an imported product. One needs to be licensed by the Food Safety and Standards Regulator. This is a separate license which needs to be obtained. In addition to the manufacturing license, an importing license, along with additional conditions, have to be obtained by the regulator. So this adds to your compliance much more, because in addition to the manufacturing, now you're also looking after the importing requirements. A lot of issues happen when we are importing the products, because if the exporting country is not able to adhere to the labeling requirements of the country, that's a problem. So that's where our compliance checklist comes handy. Along with the help of Legasis, we have been able to frame a wonderful checklist of compliances that needs to be done for all these regulations, including these food import regulations. And these requirements are given to the exporting country, which ensure that all the necessary requirements with regard to the labeling are mentioned. There are certain measures which are given if you have missed the name and address of the importer, if you have missed placing the FSSAI logo, the veg, non-veg logo, or the category name or generic name of the product by the exporting country. These 4 or 5 declarations can be stickered at the port of the importing country. So that leverage has been granted to the importers, and that helps a lot in terms of completing the compliance at the port. Certificate of analysis, again, is an important document which needs to be accompanied by any import which happens. Again, this is a new requirement, a developing requirement. Again, health certificates are developing requirements which are being introduced, which are being worked upon very frequently by the regulator. When you're bringing in a product for R&D purposes, this is another aspect in imports, which one needs to be very, very careful about. Because if you are bringing it for R&D purposes, then one must ensure that the product does not get out of the market for the consumption, for the public consumption. It should be remaining in the factory premises or the R&D facilities for research and development purposes. So there are again checklists developed how to follow those measures. One of the issues that we face here is on the parallel imports, or the gray market that you see on the shelves. A lot of products are brought into the Indian market from the countries abroad. These products, as you see, do not follow the labeling and display regulations of the Indian country. What the importers do is they want to put a sticker with the minimal declarations, not following the font size requirements. One of the challenges that we are facing is to stop or kind of look at ways how we can control such imports, because food products needs to be very, very safe. The quality needs to be very, very high. So currently we do not know at what quality or what storage conditions these food products are being brought into the market. So a lot of discussions are happening with the regulators to, making them aware that the food products that we see in the market, which are not brought in through the proper channels by following the legislations, should be stopped. Moving on, another important legislation is the advertising and claims regulation. Whatever claims that you see, either on the product or on the TVCs, which is television commercials, or digital today, are all governed under the advertising and claims regulations. As we know, the regulator has a keen eye on what the industries or what the companies are claiming for their products. So any claim that you make on your product packages should be in line with all the guardrails provided in these regulations. A lot of discussion happens with the business teams. There are a lot of gray areas that one comes across, but one needs to be very sure that any deviation may lead to either stoppage of your advertising, fines, penalties, and also initiate other proceedings by way of other legislations which also has or also governs advertising and claims. The most important function which one needs to make sure of is that all claims should not be false or misleading. So false and misleading claims are taken down very heavily by the FSSAI regulator, as well as other bodies which govern advertising like ASCI or currently the newly constituted consumer panel. ASCI, which is the Advertising Standards Council of India, they have collaborated with FSSAI for misleading claims. So in addition to FSSAI, ASCI too has the authority to question your advertising which they see in any medium. And they, after the hearing, if you are not agreeing or adhering to the recommendations by ASCI, they have the power to write to the FSSAI, who in turn will again question all your advertising. Any health and nutrition claim which you are making on your product should be backed by solid scientific evidence. All evidences may be challenged, but if you have a solid scientific evidence, your arguments will be strengthened before the regulators. What you can see on the screen are some of the advertisings which were questioned earlier. With each passing day and each regulation being, getting strengthened day by day, the industries are focusing more and more to discuss, debate, and argue internally with the brand teams, with the business teams, to ensure that it takes all the tests internally before it gets released in the market. And if at all it gets questioned in the market, you have sufficient arguments to back your claims. One of the aspects of advertising is comparative advertising. Now, we tend to do a lot of comparisons. So we thought that some certain do's and don'ts which have been brought in will be a very important or a very informative session for you. So there are certain do's when you're doing the comparative advertisements. So while comparing, you make sure that the statements are, if you're making a statement that you are the best, you're entitled to do that. But before doing that, ensure that you have all the scientific justifications or all the data to back up your claim that you are the best. You're also entitled to make the statement that we are better than our competitors. But then a lot of litigations have happened over this particular claim. One needs to be very sure of the data before going on and making such claim, because this comes with a risk. It comes with a risk where it can be reputational, because it comes in the media very quickly that two giants are at war, on the platform, claiming superiority over the other. And it costs in these litigations. IP litigations do not come cheap, so it becomes costly, becomes a costly affair for the industry as well. So be very sure of your data, be data backed, and then make such claims. What you should not do You should not demean any competitor. You should not defame or show an identical product in bad light. Ensure that you are not infringing the IPR rights of other brands. So these are certain do's and don'ts one must follow while making a comparative advertising. In addition to the comparative advertising, there are other do's and don'ts which are also developed in-house by various industries to ensure that the advertising follows all the guardrails which are prescribed by the advertising and claims regulations. Well, moving on, what happens if there are violations, if there are non-compliances? There are penalties and fines. The penalties and fines are depending on the kind of violation that you run into. These are not all, but some of them, some of the crucial ones. So if you're selling or manufacturing a substandard food, the substandard food into the market, which is not as per the standards prescribed, either for the standard product or for the proprietary product, then there's a fine of 5 lakh. If you misbrand a food product, if there's an allegation of misbranding, then there's a penalty of 3 lakh. If you're misleading a consumer, there's a heavy penalty of 10 lakh. If you're operating without a license, is a serious offense, because this moves into the other aspect of criminality. There can be fines imposed, and you will also be prosecuted criminally for operating without a license. Now, this is one major shift which has been brought about between the earlier Prevention of Food Adulteration Act vis-a-vis the Food Safety and Standards Act. Because earlier, in the earlier regime of Prevention of Food Adulteration Act, each non-compliance led to a criminal prosecution. But now, thankfully, with the FSSAI coming into picture, 2011 onwards, there are certain offenses which are penalized monetarily and certain offenses which are penalized criminally or prosecution is initiated. One of them is operating without a license. Now, if you're failing to comply with the directions of a food safety officer, a penalty of 2 lakhs can be given. The other important aspect is what happens if you're not complying with the license conditions or any order or any improvement notice that you have received from the food safety officer or licensing officer. The licensing officer has the power to suspend your FSSAI license. He may suspend initially, and if you still continue to violate, you also have the power to cancel your license. Now, this is one such aspect which none of us industries are willing to take the risks for. As a result of which, one needs to be very conscious about the compliances that they need to follow. You need to deliberate continuously, question continuously, audit continuously your team in order to ensure that you have complied with all the regulations. Moving on to the FSSAI inspections and audits. One always faces inspections and audits. In a way, they are good as well because they keep you on your toes. They keep your compliances high. So it's always good to keep both internal audits and external audits on. Sometimes the inspections may happen from the regulators as well. And they can be of two kinds. One can be surprise inspections and audits, where you're caught off guard. There's an inspection, it may be called dawn raids or dawn inspections. And one way could be an informed inspection or an informed audit. Either ways, if you are getting an informed inspection or an informed audit on receipt of any email from the FSSAI of inspection, always ensure that you reply in time and confirm the appointment. So this is one of the best practice that we have developed, that any communication that we receive from any inspector or any licensing officer informing us about any inspection or audit, we reply to those communications immediately without any delay, at least acknowledging the email, that we have acknowledged your email. It is a best practice that you should not request for additional time, because us seeking for additional time means that there's something wrong. So always respect the timeline or the timing which has been given to you by the regulator for inspections and audits. Well, if it's a surprise inspection, you have no other choice but to follow the inspector wherever he's going inside your premises. But if it's an informed inspection, always respect the timelines. During the inspection, what you should do is, in fact, when the inspector comes in, you should accompany the official at the entrance and ensure that do not wait longer, because keeping the inspectors waiting by the security personnel is not a good sign. The inspector gets agitated at the gate itself, and your resultant inspection may not, go in the right way. So the instruction that we have given to all our security team, the trainings that frequently happen to the security team, is to ensure that whenever government authorities or whenever inspectors come to the factory premises, ensure that you accompany the official and do not make them wait for long. You quickly inform the relevant stakeholders and arrange for a support team. So that's one of the other instructions that you need to keep your team aware at the office locations. You tell your security people to verify the documentation before, and seek the identity verification. Now, this is a very, very, this is a point which can go either ways, because there are certain inspectors which may feel offended if you're asking for an authority. But from your point, because there have been instances where fake people with fake identities have entered into premises, it's at best to politely make them aware that this is as per protocol, that any person who's entering the premises, at least we should see the identity before making them enter the premises. So verify the documents before they enter. You keep a dedicated room. You always pre-align a dedicated room where the inspector should be taken once he or she enters the premises. So that's one good practice that we have followed, so that they do not immediately enter the area. And all the representatives who are, kind of stakeholders or representatives who are assigned for such visits and audits, and support team should immediately meet the officials and cooperate with the officials with whatever questions they come up with. During the inspection, when the inspection is happening, when the inspector has gone inside your premises, he or she is visiting, always cooperate with these officials and be transparent about the information that you're giving. Even if you are wrong somewhere, even if you're non-compliant somewhere, be open and transparent about it. Do not try to hide any information, because that can be detrimental for the organization. Or do not try to misrepresent or mislead the authorities. They are masters of their jobs. They know what they are doing. So do not hide, misrepresent, or mislead the authorities. One of the important elements is keep your stakeholders and the persons who are accompanying the inspectors always trained that do not give additional information, because some people have the tendency to talk a lot, give information more than what has been asked for. So be very mindful, be very cautious about the kind of information that you're giving. Do not provide unnecessary documents. Provide the information and documents which have been asked for. Keep full records of the questions that have been asked. So someone should always be making notes of the questions that are being asked, the answers that are being given to the officials, so that later on you can deliberate upon those. If during the inspection, the inspector has sealed certain products or certain processes, respect the seal of the government. A lot of time we have seen what happens is once the inspector goes away, the local shop floor people are not aware about the sealing process or the process which the government follows. They tend to open or break the seal, tamper with the seal. Now, be very mindful. This message needs to be given clearly to the lowest member of the shop floor that once the process or the product is sealed, it cannot be tampered with. Avoid talking with the officials unless you are asked for. So again, one of the important aspects during the inspection is that one should avoid talking. Questions what are being asked, the answers should be very specific. And if you do not know an answer, seek time. Tell them that you will come back with this answer. You have all the time. You are not required to give all the answers at the moment. So you can take some time before you provide them with the answers. After the audit, thoroughly check the observations given by the FSSAI, either in the inspection report. If it's happening during the audit, if the inspection report or the observations are being written during the inspection, be very watchful of what is being written. Do not let them write everything and anything in the inspection report. You have the chance or you have the right to debate and discuss, of course, respectfully and politely. challenge them technically, respectfully, of all the observations that they are making in the inspection report. You have the right to do that. And we've seen in all our past experiences that the inspectors have been mindful, and they have removed a lot of points during the discussions and debates and technical discussions, even during the writing of the inspection report. One should carefully check the documents copied by the officials. So each time they will ask for a lot of copies. So keep a copy of each copy that you are providing, so that you can be sure of what documents you've provided while preparing a response later on. Be very watchful and check carefully the minutes of the inspection prepared by the officials, because there may be chances of certain additional things may not be true written on the minutes, which you may want to avoid. So one should always be watchful of the minutes which are being written. After the inspections are over, the inspector has gone, debrief all the relevant stakeholders immediately, so that you do not miss on any of the important points that may have happened during the inspection process. So debriefing session should be held immediately after the inspection has happened. Or if it is late night, as we had also experienced in our past lives, certain inspections happen overnight. It can end at 1 a.m., 2 a.m., 3 a.m., 4 a.m. in the morning. Keep the notes ready, and immediately in the next morning when the people are available, huddle them together and do a debrief. You also have the opportunity that if the inspection report has been given, certain show cause notice has been issued, certain observations has been raised, you can reply to these observations after aligning the authorities. So in order to build a rapport, what one can also do is continuously dialogue or discuss with the regulator, and you can make a reply, a draft reply, discuss with the regulator, come on the same page, and then make the response, demonstrating that you are keen on compliance if it's a non-compliance, and you have complied, or you had complied of a particular observation which they would have mentioned during the inspection. So it's a good habit that you keep the discussion on with the authorities. It helps you build a rapport with the authorities as well, and to understand where the regulator or the authority or the inspector is coming from. Keep the regulator also informed about the compliance status. So every time you're complying, if there's a non-compliance, keep them informed, and also provide additional information within the timelines that they mention to the regulator on due course. So these were a few of the things which we thought would be a good food for thought for you. Some of the key takeaways which we can take, which you can think of, was that FSSAI as an authority, as a regulator, which governs all the food products in the market, in the country, are bundled with huge powers. They have the power to take away your license, stop businesses. If you are not complying in a particular manner, you are introducing unsafe foods, you are introducing substandard foods. They can levy heavy fines and penalties. They can issue criminal prosecutions. Your licenses can be suspended. So they are a regulator who come with immense powers. So the FPOs need to be vigilant in their operations. And it brings about all the more importance to the compliance that one needs to follow. One needs to be sure and certain and updated of the compliance that one needs to do. There has to be cross-functional collaboration at the highest level, be it your quality person, your manufacturing person, your legal person, your production people. All have to be in sync and aware. The people in supply chain who are responsible to bring in or transport the products, store the products in CNFA warehouses or godowns, they all need to be aware, or they all need to be made aware of the compliance requirements which come with FSSAI, so that each and every law gets complied with and there are no resultant fines or suspension of licenses. One of the things that one needs to be very cautious about is the inspection and audit. Keep doing internal inspections and audits at regular intervals to ensure that your teams are up to their toes, their compliances are up to date. And when the regulator comes in for an inspection and audit, handle the audit very professionally and in a confidential manner, because That's what will matter. I'll hand it over now to my colleague Indranil, who will take you through some of the key features of plastic regulations, which is one of the more important legislations in the country these days. Indranil, over to you.
Thank you so much, Anjal. Very insightful. And thank you, Jaideep. First of all, for your warm introduction at the start of the session. It is indeed our pleasure to be a part of this session where we can share our knowledge and share our experience on this important topic of compliance. Fine, moving on. Plastic regulation is one of the very hot and boiling topic in the country. It's very sensitive. Plastic is one of such legislations in the country where both the central government and the state government, they have the powers to make laws on this specific topic. The reason being, environment is one such topic which comes in the concurrent list of the Constitution of India, where both the state government and the central government have the powers to make law on the topic of environment, which also includes plastic. On this slide, we'll take you through the journey of the plastic regulations, the framing of the central regulations, and the changes which happened during the year till date. So the central government, they have come up with plastic waste regulations at a central level, where the intention of the government is very, very clear to phase out all the multi-layer plastic, which cannot be recycled, or if it is non-energy recoverable, or for those materials for which there is no alternative use. Over a period of time, there has been a lot of amendments in the central government regulations. So for example, in 2018, there were amendments with respect to the marking and labeling that which mandates the manufacturer of the plastic packaging to put certain declarations on the plastic packaging. Then in 21, this is a big move. Since 2019, the central government, has signed a pledge to ban the single-use plastic item. So the government is very keen working on such issues. And in August 21, they came up with a clear-cut regulations to ban certain specific single-use plastic items with effect from 1st July 22 onwards. I'll talk about this in my next slide. Then in 22, there was another amendment to the plastic waste regulations, wherein few definitions were included. Like for example, the terminology of plastic packaging has been used in the plastic regulations, but surprisingly, there was no clear-cut legal definition of the word plastic packaging. So that clarity has been given. Also, the definition of what do you mean by post-consumer plastic waste, pre-consumer plastic waste, which again has been referred a lot in the regulation, but again, there was no clarity in the rule. So that has been clarified in the regulations. Then in 2022, the government has come up with a clear-cut guidelines on EPR. What do we mean by EPR is the extended producer's responsibility. So whatever plastics has been purchased and introduced in the market, it is the responsibilities of the entities to ensure that they have a mechanism to get back those plastic waste from the market. With this requirement comes up with a lot of responsibilities also. So it has increased the responsibilities for the concerned entities, which are the producers, the importers, and the brand owners. So these are the entities which needs to be registered under the plastic regulations. I'll again speak on it in my next slide. And with that, as I mentioned, that since it is a topic which comes under the concurrent list, every state and union territories, they have also come up with their own regulations of restricting certain plastic items. So as an entity, it is very challenging that you have a central regulation in place. Apart from that, you have to ensure that if you have business in more than 2 states, 5 states, 10 states, you have to ensure that you also have to comply with the specific respective state regulations as well. On the single-use plastic, so within the supply chain, what is banned with effect from 1st July is whether you are manufacturing, whether you are importing, whether you are storing, distribution, sale of all these specified selected single-use items are banned from 1st of July. Which are those items which are restricted from 1st of July is plastic carry bags if the thickness is less than 75 microns. Earbuds with plastic sticks for balloons, plastic flags, candlesticks. Then there are cutlery items like plastic plates, cups, glasses. wrapping or packaging film, which is used for sweet boxes and so on. All these plastic single-use items are banned with effect from 1st of July. In the next slide, you can see a pictorial image, a quick glance of what has been banned with effect from 1st of July by the central government. Moving on, as per the new EPR regulations, that is the extended producers' responsibilities, where it is the responsibilities of the entities to ensure that whatever plastics has been introduced in the market, they have a very thorough mechanism to get those plastic packaging back from the market. So there are certain entities which needs to be registered with the Central Pollution Control Board. So these are the producers, that is, who are manufacturing the plastic packaging. The second category is the importer, who is importing any plastic packaging or food products with plastic packaging. And the third category is the brand owner. For example, you have a license from your group or parent company to use that particular brand in the territory of India. So those are called brand owners. For example, Ferrero, we have registered with the Central Pollution Control Board in the capacity of importer and brand owners as well. On the categories, there are certain types of categories which is clear-cut defined in the regulations. Now, the first category is the rigid plastic, which is also called as category 1. So, for example, the candy jars, which you can see on the retail shop, those comes within the ambit of the rigid plastic category. The second category is the flexible plastic packaging, which can be a monolayer, just a one layer of plastic packaging, or a multi-layer. So, it can be more than one layer of plastics. And the third category is the multi-layered packaging, where one packaging is your plastic, and it could have another layer like paper or aluminum foil. The classic example is of Tetra Pak, which consists of paper, aluminum foil, and plastic as well. Moving on, then, as I mentioned, that with the EPR guidelines also gives a lot of responsibilities and increased compliances for all these entities, that is producers, importers, and brand owners. So one of the primary obligation is the EPR targets. So when the entities are applying for the registration on the Central Pollution Control Board portal, this system will automatically calculate the EPR target. So this target depends upon certain algorithms. That algorithms has already been defined by the Central Pollution Control Board. So for example, whatever plastic has been introduced in the market by a particular entity, whether it's a brand owner, importer, or a producer, the average of last 2 years, the sales data is taken as a base to calculate your EPR target, which is calculated by the system. Now, once these EPR target is calculated, then there is an obligation to collect those plastic packaging from the market, and there are year-wise targets. So for example, for the year 21-22, the entities had to collect 25% of the respective targets which has been calculated for those entities. Then in 22-23, the current year, the entities needs to ensure that they collect 70% of the plastics which has been introduced. And from 23-24 and onwards, it is 100%. So whatever has been introduced in the market, the entities needs to ensure that the entire plastic packaging introduced is collected from the market. Then there are two more obligations, increased compliances with respect to recycling and reuse obligations. So on the recycling part, there is again an obligation on the entities to have minimum level of recycling of plastic packaging. So again, whatever has been introduced in the market, that needs to be recycled. And again, the algorithms has been developed. If you see the targets here are again category wise. So for example, in year 24-25, the entities needs to ensure that 50% of the rigid plastic, the category 1 plastic, which has been introduced in the market, needs to be collected. 30% for category 2, that is flexible, and 30% for category 3, that is multi-layered. And you can see the targets for 25, 26, 26, 27, 27, 28, and onwards. The another obligation is the reuse obligation. Now, this is only for category 1, that is the rigid plastic. Again, you will see the algorithms have been developed by the authorities depending upon the size of your plastic packaging, that is a rigid packaging. So the challenge again here is, so for example, I gave the example of the candy jar. So if the jar has been introduced in the market, the entities needs to ensure that they come up with a concrete mechanism to get those jar back So the reuse can be for the same purpose or also for a different purpose, but you cannot modify the original packaging. You cannot play with the original packaging. Currently, this mechanism is something which the entire industry is working upon. And the obligation again starts from 25-26 onwards. The another obligation is for use of recycled plastic. Now again, you see here there is a clear-cut algorithms built category wise and year wise target is getting increased. So it is mandatory for the entities to use recycled plastic in their plastic packaging. So the idea is to get away with the virgin plastic. However, currently the food safety authorities, they do not permit the use of recycled plastic in plastic packaging. So again, this is one of the challenge which industry is facing, and industry is already engaging with the FSSAI regulators and also with the plastic regulators, so that FSSAI comes up with the clear-cut guidelines on this in order for the entities to meet this criteria of having recycled plastic in plastic packaging. Moving on, state-wise regulations are there. So we have captured some key regulations. As I mentioned that there are central regulations already in place, and then every state has come up with their own regulations for restricting certain items. So for example, if we see the central plastic waste management rules, which clearly permits plastic, for use in multi-layered packaging. So if you are using any plastic in multi-layered packaging, those are exempted from the ban. On the contrary, if you see the certain specific state regulations, for example, Chandigarh, in Chandigarh, all industrial packaging, which is less than 50 microns, are restricted. Similarly, in Jammu and Kashmir, all plastic packaging and multi-layered packaging less than 50 microns are banned. In Manipur, again, wrapping plastics, any plastic packaging and multi-layered packaging, which is again less than 50 micron thickness, is restricted by the state. Arunachal Pradesh also, all plastics which are less than 50 microns are again banned. In Tamil Nadu, there is a ban on use and throw away plastics. So the definition of use and throw away plastic is very gray, and the entire industry is working on that. Prima facie, it appears that all your primary and secondary packaging material can come within the ambit of the ban. And for Maharashtra, all recycled multi-layered plastic are exempted, and all plastics which are an integral part of the manufacturing are exempted from the restrictions. However, it should not be more, it should be more than 50 microns. One of the challenge the entire industries in Maharashtra are facing is, take example of shrink wrap or stretch wrap, which is used during transportation to wrap your commodities, your food packages. Now those are maybe 10 microns, 15 microns, 20 microns. The practical and the technical challenge which the entire industries are facing, that you cannot increase upon the thickness, because the moment you start increase the thickness of the shrink wrap or stretch wrap, it may not be, the industry will not be able to use for the intended purpose. So these are some of the practical challenges, although there is a exemption from the central regulations, but as I mentioned, it's very important that if you are having business in all these states, apart from the central regulations, it's very, very, very important to follow the specific state regulations as well. Moving on, what happens if there is a non-compliance with respect to the environmental or plastic regulations? Again, this is not an exhaustive list, but we thought to cover the key penalties. So, for example, if any entity is continuing to manufacture, store, or import and stock single-use plastic, the specified single-use plastic items, which is banned after 1st July, then it may lead to cancellation of your registration and also product seizure with fine. So this is one of the major risks, because for any cancellation, it impacts the entire business. So for example, if you have only one factory in a particular state or in a country, it might have a huge impact if there is a stoppage of business operations. Non-compliance of labeling norms, as I mentioned in my previous slide, that there are certain compliances. Again, it may lead to cancellation of your registration and fines. With respect to the EPR targets, if any particular entity is not able to meet with the EPR targets, then again, there are huge fines starting from 5,000 per ton, and for the second time, 10,000, 20,000 per ton, so on. So every time the fines will get increased per ton. There are also certain additional compliances for the entities to file annual returns in time. If those are not filed in time, then again, there are penal consequences. At the time of registration, we have to be very, very careful of whatever data we are giving to the central government, because in case if there is any false information has been given knowingly or unknowingly, then again the risk is high in terms of penalties as well. The key takeaways are, as we know, the single-use plastic ban has already been implemented. So one has to be very, very careful with respect to the single-use plastic ban. One has to follow the central regulations and also the state regulations, because the risk is very high, not only in terms of fines or penalties or license suspension, but overall your brand image can be at stake. We are very well aware about the intention of the government to reduce the plastic waste, and that has been taken very, very positively by the entire industry. But yes, as mentioned, there are some practical problems, there are some technical problems. So it's very important that industry works with the regulators and find an amicable solution to ensure that these restrictions are taken very positively, and also there is solution for the challenges which the industry is facing, and for which industry is working very, very closely with the regulators as well. With this, we thank you for giving us this opportunity to share our knowledge and experience, because compliance is one such topic which is very close to everybody's heart, and it comes up with a lot of risk and challenges. If there are any questions, if you would like to reach out to us on both these topics, whether FSSAI or plastics, you can reach Mr. Anjal Raj on the email ID and myself. Thank you so much. Jaideep, over to you. Thank you.
Thank you, Anjal, and thank you, Indranil, for such a wonderful and a very, very well-researched session. I am sure all of our viewers are enlightened, and you have given lots of food for thought to us, and back to our drawing boards in many, many cases which you have given. The concepts of proprietary food, the licensing and the packaging regulations, the comparative advertising, and the analysis of packaging and the nuances of it is certainly going to make us turn around our kind of package that we buy off the shelf and look at the detailing which you enumerated very, very succinctly and very, very aptly. The practical examples, the awareness of how you should be conducting, orienting, training during audits and other protocols that you mentioned will surely be takeaways for most of us. The best practices that you enumerated that you have followed in your organization are certainly takeaways for others also. Indranil, your appropriate analysis, comparative specificity, and the awareness of how and what should be going into when you analyze these plastic regulations was certainly very, very enlightening for all of us. We are very, very thankful that you could make this a very, very good session, very analytical session, and thank you for being a part of this great Compliance 1010 event. We are once again thankful to you, and we hope that all of our viewers are enlightened by it also.
Thank you.
Any
Thank you so
closing
much.
comments, Anjal? Any closing comments, Indranil?
Thank you so much, Jaideep, for giving us this opportunity to speak on a few of the important topics in your Compliance 10 on 10 Symposium. Well, within an hour, we tried to capture whatever we could. Both these topics have a lot of compliances which get into it. Every industry has a lot of other regulations, which has a lot of compliances connected to it. What I would like to emphasize on is always be updated. Keep studying, keep yourself active within the industry discussions. That is the only way. Keep your networks high. That is the only way you would be aware and conscious about what are the key regulations and legislations which are either being drafted so that you can deliberate upon them, or have been finalized, which will ensure you to sit down on your drawing boards and sketch the compliances which should be mapped to the individuals within your organization. So keep doing that. That's how you stay awake at night. All the best to all of you.
Thanks, Anjal. Thanks, Indranil, once more. Thank you. Thank you all for joining in, and we hope that it was an enlightening session. your Q&As are with us. We will get back to you after the speaker's consensus on the same, and some part of it also will be done after we share the presentation with you. Once more, we thank you for being part of it. Join us for the webinars on the 6th and on the 7th, the invites for which you will receive shortly. If not already, you must have registered for it. Thank you once more for making this a great event. Thank you.